Dispute resolution. Thank you for joining us. I'm Carrie Chilton.
And I'm Kalina Eck.
We're staff attorneys with the Disability Law Center of Virginia, and we'd like to tell you a little bit about dispute resolution options when a parent and school disagree about special education issues. What can a parent do when they disagree with the school? Maybe they have voiced their concerns at IEP meetings, but the school does not agree with a parent's concern or request. Both IDEA and Virginia special education regulations contain information on options a parent has when they get to this point. Generally, there are 3 ways a dispute about special education can be resolved. They are mediation, Virginia Department of Education complaints, also called a state complaint, and due process hearings. We have included citations to the Virginia regulations that discuss these. In this session, Kalina and I are going to walk you through the process for each, explaining their upsides and downsides, as well as what each option is best suited to resolve.
The first level of dispute resolution is mediation. This is the most collaborative and least adversarial of the dispute resolution options, and really where we recommend parents and clients start when negotiations at the IEP level aren't going well. In VDOE mediation, the school division and the parents must jointly agree to participate and send in a joint request for mediation. Either party can refuse to participate in mediation, and it can't be used as a delay tactic by either side. Mediation is a confidential process, so any new information learned there can't be used in other dispute resolution processes later. As Carrie will discuss in our next slide, parents can pursue mediation and other dispute resolution options at the same time, but there are some timelines you'll want to keep in mind if you choose to do so. Mediation is a negotiation, but with a neutral third party in the room as essentially a referee. The mediator won't decide which side is right or wrong, but serves to keep the negotiation moving forward, hopefully to a mutually satisfactory resolution, or to identify when the parties have encountered an impasse. This is another reason we recommend mediation as a starting point, because parents retain some level of control over the ultimate agreement, as opposed to a final decision maker making the plan for going forward for them. If an agreement is made, it is legally binding on both parties, and the issues resolved are considered fully settled. Parents cannot seek a better deal through other dispute resolution options once an agreement is made. In our practice, Carrie and I often see mediated agreements that are vague, and those are hard to enforce in court, so make sure any agreement is clear about who is supposed to do what by what date. And finally, be aware of any confidentiality clauses and what they mean. If you agree to confidentiality of terms, you can't share it on Facebook or with another parent in the school or anyone not a party to that agreement. Carrie and I were just at a conference recently where a presenter was telling us a story about a man who had reached a generous settlement through mediation and had specifically accepted his wife from the confidentiality agreement. However, he told his daughter, who then posted a picture on Facebook with a caption saying something like, "Ski trip courtesy of Dad's settlement with the company," which of course voided the entire agreement and the man had to return all the money. So be careful with those confidentiality agreements and really understand what they mean and get in writing exactly who you can share the information with.
Another option parents have is the Virginia Department of Education complaint system. A parent is not required to go through mediation prior to submitting a complaint. If a parent would like to try mediation as well, they can request mediation and file a complaint if the mediation is not successful, or they can request mediation on the complaint form itself. Keep in mind that the timelines for the complaint process will be ticking if you choose the second option. This may be a good thing or a bad thing, depending on the specifics of your case. The VDOE complaint process is best used for procedural violations of a student's or parent's rights. For example, if the school did not complete an assessment within the time required, or failed to provide a child with a service in their IEP. You must submit a copy of the complaint to the school at the same time you submit it to VDOE. VDOE will investigate your complaint. This could mean looking at educational records, speaking with people at the school. VDOE has 60 calendar days from the time you file the complaint to when they issue their decision. This timeline can be extended if there is exceptional circumstances or if the parents and the school agree to extend the timeline so they can try mediation first. VDOE will issue a letter of findings based on its investigation and will determine if the school violated special education law, and if so, what the school must do to fix the situation.
So if mediation was the least adversarial of the dispute resolution options, due process is probably the most adversarial option. As with a complaint, a parent doesn't have to go through mediation or the complaint process before filing for due process, though we certainly recommend attempting mediation as a first step if at all possible. Due process is best used when there's a disagreement about the type or quality of services the school is required to provide to ensure a student receives a free, appropriate public education. You may have heard us refer to that as FAPE in some other videos, and we go into more detail about what FAPE is and isn't there, but basically due process is best used for when a parent and school disagree about what a student needs to be able to access the curriculum and make progress on the goals in the IEP. Parents and school divisions can both request due process, and it doesn't need to be a joint request like mediation. Due process has a longer look-back period than the complaint process, looking back 2 years instead of the complaint's 1 year. Anything that happened more than 2 years before the filing date may be helpful as background, but unless it fits into one of those exceptions listed on the slide, a due process decision won't be able to fix or remedy those alleged violations. Due process is an administrative hearing where there will be opportunities to submit evidence, provide experts and other witness testimony. We'll talk more about the appeals process in a few slides, but it's important to note that this is where what we call the record is created. So it's very important that all the evidence the hearing officer will need is included. That's one of the reasons we recommend parents work with an attorney to represent them and their student at due process, to make sure all the evidence that needs to get in is in properly. Also, the school division will almost always be represented by their attorney at a due process hearing, so parents really want to have legal representation as well. So the hearing officer listens to all the arguments, looks at the evidence presented, looks at the law, and then issues a decision based on all those and what we call the preponderance of the evidence standard. That's the fancy lawyer way of saying the hearing officer decides who has just even the tiniest bit stronger evidence.
This slide is a broad overview of the timeline for due process. Due process is a complicated procedure and looks different in each case. This is just to give you an idea of how long the process can take, but it is not comprehensive and does not include every possible step. Due to the complexity of due process, DLCV highly recommends that you work with an advocate or attorney if you are considering this option. Due process starts when the school or parents file a notice or request for due process. If the other party believes that this request is missing necessary information, they may challenge the notice within 15 calendar days of it being filed. A hearing officer would then have 5 calendar days to determine if the notice contained all the required information. At least 5 business days prior to the hearing, each side must provide the other with witness lists and documents they plan to provide to the hearing officer. The hearing officer must then make their decision within 45 calendar days after the 30 calendar day resolution period ends. So, the school and parents have about a month to try to resolve things informally without a hearing, through mediation or other ways. And then within 45 days after that month, the hearing officer has to make a decision. This shows you just how long due process can take. If the parents or the school disagrees with the hearing officer's decision, they can appeal to federal or state court.
When a parent disagrees with the decision made through the VDOE complaint process or the due process hearing officer's order, the next step is to pursue an appeal. There's no appeal for the mediation process because there, the parent is in control of whether or not to agree. But for those cases where there's a third party making the ultimate decision, there is an appeals process. These appeals have to be based on either newly discovered evidence that couldn't have been presented at the initial complaint or due process hearing, or an error of fact or law. Basically that VDOE or the hearing officer got it wrong because they misinterpreted a fact or misapplied a law. Any appeal has to state exactly what those errors were. A complaint is appealable back to the Virginia Department of Education and must be filed with them within 30 days from the letter of findings. A due process decision is appealable to State Circuit Court within 180 days from the decision, or Federal District Court within 90 days of the decision. There are pros and cons to either court, and we strongly recommend parents discuss those pros and cons with and be represented by an attorney in that appeals process.
So, we know that dispute resolution can take a long time. What happens to a child's education and services during this time? Special education law uses the concept of stay put, while a school and parents try to resolve disputes. This concept applies to any formal dispute resolution process. While a dispute is being worked through, a student stays in their last agreed upon placement and continues receiving the services in the most recent signed IEP. There are two exceptions to this rule. First, when a party is appealing a hearing officer decision in state or federal court, the hearing officer's decision acts as the new stay put. If the hearing officer agreed with the parent on a change in placement decision. Otherwise, normal stay put rules apply. Second, the concept of stay put does not apply to a change of placement that arises from a disciplinary action. So, for example, if a child is placed in an alternative school due to being expelled from his zoned high school, the child would remain in the alternative school during the dispute resolution process. Thank you for joining us. We hope you found this information helpful. For additional resources, please visit our website at dlcv.org. In addition to online education, DLCV provides in-person trainings as well as individual advocacy in some cases. Follow DLCV's Facebook page and website for trainings in your area. If you would like to request individual advocacy services, please see the contact page on our website.